Hello. Ladies and gentlemen, dear friends, I want to welcome you to the high-level roundtable on transatlantic data flows. And in particular, I would like to welcome the thousands of viewers joining us on the Lisbon Council YouTube channel for the live stream. It's a pleasure to have you all with us here today, and a sign that for many, transatlantic data flow is not an obscure field for legal arguments, but a vital pillar in a prosperous, well-run global economy. Indeed, the mere fact of the video stream I just mentioned, crossing the ocean as it were, is an example of the huge role that transatlantic data transfers have made in bringing us all closer together, and we welcome this development. For those of you who don't know me, my name is Paul Hoffines, and I'm president and co-founder of the Lisbon Council, a Brussels-based think tank. And the Lisbon Council today is only one of two co-hosts. I also want to welcome our friends and colleagues from the Progressive Policy Institute, including I'm proud to say friend, Will Marshall, who will be speaking to you a little bit later this morning. Together with PPI, we've established a long-standing and now thriving transatlantic think tank dialogue, running for 3 years now. This is the 5th time we have convened together on various issues surrounding the transatlantic relationship, and in particular, the emerging transatlantic trade and investment partnership. The collaboration has produced already 2 policy papers, some of which you may have seen, both of which were written by myself and PPI's chief economic strategist, Mike Mandel, who also joins us in the corner there. Hey, Mike, it's very nice to have you in Brussels with us again. Our latest policy brief is called Uncovering the Hidden Value of Digital Trade, and for those of you who are interested, you'll find it on the Lisbon Council and PPI websites. I don't think I need to tell you that today's discussion is extremely timely. After the European Court of Justice's Schrems ruling, the European Union and the United States have opened talks on the future rules that will govern the economically critical function of data transfers between the EU and the U.S. This discussion will attempt to answer some very easy questions like, what common rules can we actually agree? What are recent developments in the data privacy field in the U.S.? And how do the European Court of Justice's ruling and the soon-to-be implemented General Data Protection Regulation change the framework for the EU? And before I introduce our speakers, I'd like to have a few housekeeping announcements. For those of you with cell phones, could you put them on silent, please, for the duration of this session? If you're using Twitter, the hashtag is #LisbonCouncil, #LISBONCOUNCIL. I look forward to reading your tweets, by the way. The session will run for 1 hour, and we'll be serving a drink afterwards on the patio from 5 o'clock on, and I hope you can all join us for that. The session is on the record. We have journalists in the room, and for the journalists that are here, if you do quote from one of the speakers, we would kindly ask as a courtesy that you mention they were speaking in Brussels at a Lisbon Council PPI roundtable. Now with that, it's my very great pleasure to introduce our first keynote, Julie Brill, Commissioner of the United States Federal Trade Commission. Commissioner Brill was sworn into her current position on the 6th of April, 2010. Her work is dedicated to protecting consumer privacy, encouraging appropriate advertising substantiation, guarding consumers from financial fraud, and maintaining competition in industries as diverse as healthcare and high tech. Sounds like an easy job, Julie. Commissioner Brill has been named, and I quote, the Commission's most important voice on internet privacy and data security issues. That was from MLEX Newswire. She's also been called, and I quote, a key player in U.S. and global regulations by Inside Counsel magazine, and one of the top minds in online privacy by a blogger named Varonis, some of you may know. By other accounts, she's one of the top 4 people in the U.S. government on the data privacy debate and one of the top 50 influencers on big data. In 2014, she received the Privacy Leader of the Year award from the International Association of Privacy Professionals. Commissioner Brill, it's truly a pleasure to have you with us. In particular, you gave us a bit of a scare with that snowstorm over the weekend. But you found a way around it, as you do in so many other areas. And let me just first of all thank you for being with us, and also thank you for the extremely difficult and vital work that you do. The floor is yours.
Thank you so much, Paul. Oh, thank you so much, Paul. And it's really a pleasure to be here, and I'm so honored that you're having me and Bruno to chat about these incredibly important issues. And thank you to the Lisbon Council and, of course, to the Progressive Policy Institute and Will for organizing this event. Look, let me just dive right into this. There is a big picture involving transatlantic data flows that is much bigger than Schrems and much bigger than Safe Harbor. We are at a pivotal time for data protection. both in the United States as well as in Europe. With the Internet of Things, where huge amounts of sensitive data are going to be collected, where there are risks actually of physical harm to the extent that the devices that are connected to networks can be hacked themselves, not just data issues, but actual physical harm issues, and where we'll have devices that are always on, such that for most consumers, the internet will actually disappear, as Eric Schmidt said. Everyone will get used to connected devices just in the way that they're used to electricity now. In addition to the Internet of Things, we will have big data and big data analytics, where the increased ability to process huge amounts of data in real time will mean that companies, data brokers, analytics firms, and others will be able to infer sensitive characteristics about individuals, and where there will be a potential for unfair use as well as discriminatory use, an issue that we just wrote a very large report about and issued this report just a few weeks ago. And then another very large issue that will have an effect on transatlantic data flows is, of course, the GDPR, the General Data Protection Regulation, which is finalized now, but will be implemented over the next 2 years. All of these events and phenomenon make it more important than ever for the US and the EU to have predictable rules for transatlantic data flows, to cooperate on enforcement, and to exchange ideas about protecting privacy in this rapidly changing world. So, in the midst of all that, we have the Schrems decision, which I believe has made all of this, our future-looking task, more difficult. It, of course, invalidated the European Commission's decision in the year 2000, before Bruno and his colleagues were involved, involving safe harbor. So as a result, of the decision, we no longer have a transparent transatlantic data protection framework. The discussions that have been underway, and actually they were underway before the Schrems decision, they were really underway ever since the Snowden revelations and since the Commission demanded changes and discussing changes back in the year 2013. But this issue has absorbed a lot of energy on the part of the United States government officials as well as on the part of the EU Commission officials. This is energy that we're not spending on thinking about the Internet of Things and the benefits and potential risks, that we're not spending on big data, and that we're not spending in terms of planning how the GDPR will affect not just very large companies and not just consumers, but also small and medium enterprises. So the focus of the ECJ's decision, the European Court of Justice's decision, of course, was a lack of findings on the part of the Commission with respect to law enforcement and the intelligence community's access to data that was transferred to the United States under safe harbor. The other focus of the decision was the apparent lack of findings relating to the extent of redress for European consumers with respect to this kind of access, both by law enforcement and the intelligence community. The Schrems Court also talked about the need to show essential equivalence between the United States or any country that was going to be granted an adequacy decision, and essential equivalence between that and the EU legal order. The court also enhanced the data protection authorities here in Europe by allowing them to suspend data transfers that were covered by safe harbor or an adequacy decision, although the court did say that only it could invalidate a transfer mechanism itself. All right, so all of this begs the question, is the United States essentially equivalent to the European Union legal order? Now, there are some who say that the test is going to be whether or not the U.S. compares to the European legal order's principles. That is, as they're written, does the U.S. and all that is happening in the U.S. live up to the principles? There are others who argue what we should be looking at is not just the principles, but how they are practiced on the ground by member state countries. Frankly, I think whichever test one uses, you can look at what the U.S. has been doing and has had in place, in some cases for centuries, with respect to protections against government access to data. These protections are strong, and I think that they do show that we are essentially equivalent. We have constitutional protections under the Fourth Amendment for inappropriate access by government law enforcement in particular. We have a Wiretap Act. We have the Electronic Communications Protection Act. We have the FISA law and the FISA court that oversees access by the intelligence community. We have the Privacy and Civil Liberties Oversight Board, which also is an independent agency that examines some of the ways in which this information is accessed. And just last year, the Congress enacted and the President signed the USA Freedom Law, which enhanced many of these mechanisms to ensure more appropriate and more rigorous oversight of much of this activity. In addition to the laws that we have on the books, the Presidential Policy Directive number 28 was put forth by President Obama and added additional protections that could be added by the administration alone, even without new laws being put in place. That's on the national security and law enforcement side. When it comes to consumer protection, I really think that in the United States, our system for protecting consumers' commercial data is second to none. By the way, I should point out that the European Court of Justice did not focus at all on what is happening with respect to consumers' data that is being transferred from Europe to the United States. There was no question raised by the court about the effectiveness of either the Federal Trade Commission, my agency, which is the United States' leading consumer protection agency, nor was any question raised about the laws that we have in place. With respect to our enforcement, we have rigorous enforcement, and I don't have the time to go into it, but I'm happy to go into it with respect to questions. We have brought literally hundreds of cases involving privacy, data security, children's online privacy protection, financial privacy, health privacy, credit reporting, which is an issue that I do want to talk about in one moment, kids, I think I mentioned that already, and schools. There are very protective laws when it comes to sensitive information in the United States. These laws are highly protective, in my view, actually more protective than what exists here in Europe. And I want to just give one example if I can. I recently learned that there is a very important mechanism that exists in the United States, which apparently doesn't exist anywhere here in Europe. It's going to take me 2 seconds to explain it. We have a law that says if data is collected or used for the purpose of making decisions about consumers that relate to credit, that is loans, insurance, housing, or employment, whether they'll get a job or get a promotion, that information is subject to pretty strict requirements, both in terms of access that consumers have to it and in terms of how the information is used. Most importantly, if the information is used in a way that harms consumers, that is, they have to pay a higher interest rate on a loan, their insurance is more expensive, or they don't get a job or a promotion, based on this information, it's when it comes from a third party and is sold to a user, then that consumer has to get what's known as an adverse action notice. They get a just-in-time notice that says, your data, something in your credit report has caused your loan to be more expensive, or your insurance rate to be higher, or you didn't get the job that you applied for. And what does that do? That gives consumers the just-in-time, perfect teaching moment for them to say, oh, I better go look and see what's in my report. And if entities are providing this information and they don't realize they're a consumer reporting agency, or they're using this information and they don't realize they've used a consumer report to make these decisions, then they have violated the law too. My understanding is these adverse action notices, these just-in-time notices that tell consumers how information might be used to harm them in significant ways, does not exist in Europe. So who's equivalent to whom? Who's more protective than whom? I think we really need to have an honest conversation about all that exists in the United States. It's not easy to understand. Believe me, there are lots of folks in the United States who don't understand this. Okay, it takes someone like me who's been doing this for 25 years to understand the full, or, there are lots of people like me, believe me, it's not just me, but, to understand the full breadth of the kind of protections that exist in the United States. But where we do act, and the decisions have been made to act where the information is particularly sensitive, where we do act, we are highly protective. So let me just close, at least with these opening remarks, by saying, I do believe that the United States and the EU need a stronger data protection transfer mechanism. I've been saying this for a couple of years. I think that the European Commission, along with the Department of Commerce, as well as with the FTC by their side, have been working for 2 years to reach and to develop a better, more effective data transfer mechanism. Many of the issues that we saw as being potentially problematic have already been addressed by the Department of Commerce in terms of improving its website and doing a number of other administrative things. We at the FTC, the US's leading consumer protection agency, we will continue to commit to work with the DPAs here in Europe with respect to any referral that they send us that appears to be a legitimate problem. We have committed to take a look at it, to investigate it, and to proceed as appropriate. We will commit to work with them on ensuring that we have good mechanisms in place to get information from them. But most importantly, what we really want to do is work with them on these future issues, these forward-looking issues, where we can be thinking together about how we deal with notice and choice, where there are no user interfaces. That's what connected devices will have, no interfaces. So how do we give consumers notice and choice? How are we going to deal with big data analytics that could potentially use information in an unfair way or discriminate against consumers? These are the kinds of things that we really want to work with Europe on so that we can have some convergence in terms of how we're dealing with the future of rapidly changing technology. Thank you very much.
Thank you, Julie. It's my great pleasure to introduce Bruno Gencarelli, who many of us, I think, in the room already know. Bruno is head of unit for data protection at the European Commission's Directorate General for Justice and Consumers, which oversees Europe's data protection rules from their conceptualization to their implementation in EU member states. He's also a bit less known associate professor of competition policy at Sciences Po, one of Europe's most prestigious universities. And before he joined the European Commission, he was référendaire in the European Court of Justice for more than 6 years. So he obviously knows this topic well from several different sides in the debate. Bruno, we're delighted you can be with us, and thank you as well as I thank Julie for the difficult work that you do. The floor is yours. It's a pleasure.
Thank you very much. Thank you very much for the invitation. It's a pleasure to be here. It's an honor to be next to Julie. And let me start by saying something. It's indeed problematic, a complex and sometimes problematic area of the transatlantic relationship, and we are testing that these days. But it's also, we have exactly, as you said, we have to have a bigger picture, and I would like to start with the bigger picture. It's also an area with a very rich debate, an area of convergence on some aspects, of potential, even more potential convergence. And there's a very simple reason for that, because we are facing the same challenges in terms of privacy, in terms of security of data, and we are trying to seize the same opportunities. I think the Podesta report on big data was, the title of that report was Preserving Values and Seizing Opportunities. I think that's what we're trying to do. And that's reflected in many areas. Certainly, we have a lot to learn from enforcement and from the role of the FTC in the United States that we value greatly, including in the context of the safe harbor. That convergence or the fact that we are maybe, and we will be equipping our system with more convergent tools, is also reflected in legislation, maybe not so much visible at the federal level in the United States, although the administration has called for the enactment of a consumer privacy bill. But if you look at states level, you see a very dynamic privacy landscape with many states adopting legislation, and legislation which is not so different from ours. We have even, I would say, draw inspiration from that legislation from some aspects of our regulation. Data breach notification, which is a big innovation of a reform, is coming directly from the other side of the Atlantic. It's an area also where it might be almost ironical to say this, but we have success stories, and I'm not ironical on that. I believe in them. Less than 6 months ago, we have initiated a very important agreement, the umbrella agreement, in the area of law enforcement. Few believed that we would ever be able to agree on common standards, common protection, common rights of access, rectification, administrative address in a so sensitive and delicate area like cooperation for law enforcement matters. We are waiting, and we hope this will happen soon, for a very important step of that process, the adoption by Congress of a judicial redress bill, which would allow us to move forward with that, I think, extremely important agreement, which shows, by the way, that privacy, clearer rules and better rules in the field of privacy, and a closer cooperation in law enforcement could be two sides of the same coin. So you see, it's the transatlantic, I would say, landscape in the area of privacy or data protection, as we call it here, is much more complex, diverse than just the safe harbor. And indeed, we have to, and the safe harbor talks are an opportunity to do that. We have to understand each other better, understand our different systems, institutions, etc., and to respect those differences and to work with this, with those differences. But I know that I'm here because you want me to say something on the safe harbor talks, and I will say something of the safe harbor talks, and they are, of course, very important. The Schrems ruling, some might like it, some might like it to a less degree, but that's the judgment of our Supreme Court, and it has to be respected and complied with. That should be very clear, and our American friends who come from a very legally weighted system and legalistic system sometimes understand that very well. So I'm not going to now enter into a bigger description or discussion of what is the Schrems ruling, but let maybe remind 3 important lessons that we have to draw from the Schrems ruling. Also because I think it's important to understand what the Schrems ruling is about and what that ruling is not about. First, important point, the court does not call into question the Commission's role and power to adopt adequacy decision. Rather, as it has already said, it clarifies the requirements applying to such decision and the test that the Commission has to fulfill in order to make an adequacy finding. And clearly the court has raised the bar, or at least clarify where the bar is, by saying that the standard which is applicable to such finding is indeed, and we might want to come back on this, a standard of which consists in not requiring that the level of protection is necessarily identical, says the court in the foreign country in question, but essentially equivalent to that of the EU law as interpreted by the court. The elements, also the court has clarified which elements of the third country system the Commission has to take into account when carrying out an adequacy assessment, and this should be necessarily a global, comprehensive assessment that looks, says the court, at all the circumstances surrounding the data transfer to that third country, in light of the domestic law, the international commitments that a country may have. And this includes, and we know how it was important in this case, the condition, limitation, safeguard under which public authorities can have access to the data for all sorts of legitimate reasons, national security, but also law enforcement and other public interest reasons. Second important aspect of the judgment that is even more relevant when we are talking about the safe harbor. The judgment does not call into question the adequacy power of the Commission, but says also that the Commission may well adopt and considered as adequate specific systems, such as the safe harbor, that rely to a large extent on self-certification, says the court. However, in this case, and this is an extremely important paragraph of that judgment, in general, people who are reading the judgment or have a first read of the judgment focus very much towards the end of that judgment, because that's where you have, if I may say so, the juicy stuff on the national security, access, etc. But there's an equally important paragraph, which is paragraph 81, where the court says, well, Commission, you can adopt your adequacy decision. You can even adopt adequacy decisions that are partial, that are based on different systems. So there's a certain a margin here on the way we can design adequacy, if you want. But in that case, in the case of the systems that rely, for instance, as the invalidate safe harbor to a large extent on self-certification, you must have, says the court, effective detection and detection and supervision mechanism enabling any infringement of the rules to be identified and punished in practice. I think each and every word of that paragraph are important. Effective detection, supervision, any infringement identified and punished. I may come back to that a bit later. And then the court tells us another very important thing, a lesson for us, first of all, for the Commission. An adequacy decision is a living decision. You cannot just, Commission, take your adequacy, make your finding, your adequacy finding, put it in a drawer and forget about it. You have to periodically review in light of the possible developments of the foreign system. So there must be this mechanism, this system of periodic reviews. So those are, I would say, important parameters that, of course, we have to take into account in our talks on the new arrangement for transatlantic transfer in the commercial area. So let's also say, and I think that was also mentioned, that ruling didn't come so much as a surprise. We knew, and I think this is something we shared with many of our American partners, that in a certain sense, the safe harbor, if I can say something, had been the victim of the passing of time. The enormous developments of transfer, their value, their volume, the numbers of safe harbor of companies that adhered to the scheme, to the regime. I think it was multiplied by 3 in 10 years. So we knew, and that's why we start on the basis of 13 recommendations, which issued in November 2013. We knew we had to modernize that system, and indeed we did. We have done a lot of work in the last 1 year and a half, 2 years, on very important issues. I'm not going to enter into details, but issues as important as the regime for what we call onward transfers. What happened to the data once it has landed in the US after having being transferred through the safe harbor, and is then passed to passed to another company for sub-processing operation, etc. Having clear rules and strict rules is important so that the protection travels in a certain sense with the data. No cost access to alternative dispute resolution mechanisms, that's also something on which we agree. More transparency, more user-friendly information. All this I think was very good progress on which indeed we can build, but we have also to realize that the court requires us to go further. That's also very clear, because what we have to ensure is a sustainable framework, and a sustainable framework means a framework that can pass the test of the court, and that can be durable, and that can be indeed that basis that sustainable basis, providing both legal certainty to a business and a high level of protection. So on that basis, on the basis of the Schrems judgment, on the basis of the work we have done, what are the areas we are covering in our talks, and which which will be decisive to find an agreement. First of all, we need a system guaranteeing that individual complaints by EU data subject are investigated and resolved. What the court clearly says in this judgment is we are in the area of fundamental rights. Our data subjects are entitled to have their complaints remedied, resolved. There are many ways to do that on both sides of the Atlantic. The problem, but the solution, I think, is to find the proper model mix that could combine the actions, indeed, on of our, if I may call like that, our data protection authorities on both sides of the Atlantic, our privacy enforcer on both sides of the Atlantic, to make sure that indeed there are no missing gaps, that when there are complaints, they are properly handled, investigated, and resolved. And we are discussing several models that involve the enforcers on both sides of the Atlantic, and I think we can and we should find a solution on that point, as of course on the other 2 points I'm going to very briefly mention, because I understand that I've already spoken too much, but we need that's very clear also from this judgment. We need strong and clear assurances that access by public authorities for national security, law enforcement and public interest purpose is limited, as says the court, to what is necessary and proportionate, in particular through limitation to for instance, surveillance and individual safeguards. We recognize that a lot has been done in the United States since 2012, 2013, and that the facts and the legal landscape or the legal framework of today is different than the one which gave rise to the facts that were brought to the court. You will understand that we need, because we will have to provide those assurances, we need a number of clarification, and we also see elements on which we can build. And the third important element is this element of living document of living decision I was mentioning, that we need a monitoring, continuous monitoring through an annual joint review, on which we already agreed, that covers all aspects of the functioning of the arrangement, including increased transparency on the degree of access to data by national security authorities. So there are solutions, there are models that have been discussed in these very days. So that's why I'm not going to enter into any more detail. Also because after this our conversation, I will go back to the meeting room. But the models and the solution we have put forward are models that we believe are pragmatic, because we approach those talks with a sense of urgency, because we need to provide legal certainty and protection, and we still believe that an arrangement, a revised arrangement, is the best way to provide that legal certainty and that level of protection. I was saying a sense of urgency and pragmatic solution that build in part on what already exists in US law, was introduced in US law. For instance, you mentioned the Freedom Act. The Freedom Act has very interesting aspects on transparency. For instance, transparency reports by company, on which I think we can build on in the solution, or on what already exists already existed in the safe harbor, in the invalidated safe harbor for certain aspects, or in other tools for transfers as standard contractual clause or binding corporate rules. That means that it's feasible. We can't find a deal, but we need certainly we need to work on the areas I mentioned, and And we need, as I said, we have approached those talks with a sense of certainly urgency, with a pragmatic and constructive spirit, but also, and that's very important, and that's what any responsible institution around the world should do, with a clear, a very clear requirement that the arrangement we want, and we should agree, and we can agree on that arrangement, I believe, rapidly, should be a sustainable arrangement. An arrangement that can pass the test of the court, in particular, because I think that's what we owe our businesses and our citizens on both sides of the Atlantic. Thank you very much.
It's my very good pleasure to introduce Will Marshall, whom I already mentioned in my introductory remarks. Will, what will you take away from today's discussion, and how can we drive forward data-driven innovation, and how do you think that we can contribute to a successful outcome here?
Well, thanks, Paul. First of all, thank you for being such a great partner. As you mentioned, this is one of a series of collaborations that we've undertaken between PPI and Lisbon over the last 3 years, both here in Brussels but also in Washington, to try to illuminate the larger stakes involved in these sometimes fraught battles over privacy or data localization or clouds and all these sorts of things that we're encountering. And so I want to just for a minute talk about the high stakes of this high-level dialogue, and then try to bring some new facts to bear, because that's something that at PPI we try to do, so that the debates don't get overly familiar, but are informed by new findings and evidence. Why are we so interested in this dialogue? Well, just the broad context here is that we have been monitoring and measuring, and Michael Mandel, our chief economist, has really been in charge of this, the growing contribution to growth that digital cross-border data flows, the data innovation and trade are making to growth on both sides of the Atlantic. We think that this is, unfortunately, a not well-measured phenomenon, as you and Michael wrote in the last report that you mentioned, and so we're trying to do a better job of capturing the tremendous value creation that's going on here. It's been the bright spot in the transatlantic economy in general over the last decade or so. The United States has been in a slow growth rut basically since 2000. Europe's growth rates are also not very robust. So we think this is the great problem that we face in common, this great stagnation. And I believe it's at the heart of many of the political discontents that we face in common across the transatlantic community. This at the root of this angry populism that's given rise to nativism here and there, a new political extremism and polarization, and has certainly sparked some very weird presidential candidacies in the United States. I'm sure you've all been following with great attention. We believe there really is something like a crisis of confidence throughout the Western world, in this Western model of liberal market democracy. We used to take it for granted that this market produced the world's highest living standards and the biggest and most robust middle classes. We can't take that for granted any longer. There's some breakdown in the model, and we have to have a new proof of concept here. And to us, the key is innovation and diffusing innovation across the entire economy. And so that's what lies behind this, our engagement in this long-running dialogue with our friends here at Lisbon Council, and even before with other European partners over the last 2 decades. This is the most important economic relationship the United States has. One I think has been a little bit neglected in recent years, and we want to make sure that more people in Washington certainly are thinking about how to strengthen the habits of economic cooperation that have atrophied since the end of the Cold War. The second point is that we do try to bring new facts to bear on the situation. And Michael Mandel has pioneered a new methodology for measuring the fruits of digital innovation. And just this week, PPI released a new study of the app economy in Europe, that is, app job creation in Europe. This follows on work we've done on app economy job growth in the United States. And the numbers are just remarkable. The EU plus Switzerland and Norway, 1.64 million app economy jobs. Keep in mind this has happened in less than a decade since the advent of the first smartphone in 2007. And then the opening of the App Store in 2008 by Apple. This is an infant industry that's on a faster growth trajectory than any other industry that we can think of. This rate of job creation is nearly at the same pace as we've seen in the United States, 1.6 million. Very little difference, coincidentally enough. And from these numbers, what we conclude is that mobile apps development is just a powerful job creator on both sides of the Atlantic. And this week's report highlights a European success story in mobile app development. Folks here are in the forefront, generating lots of jobs. Entrepreneurs here are benefiting from the massive investment in the infrastructure that enables digital innovation that's been made on both sides of the Atlantic, and yes, by some of the big tech companies in the United States. But what we see here is mutual gain, mutual advantage. And that's an important point because it is all stemmed from the open, free flow of data across national borders. One arresting fact from this new report: France has seen app job growth of 229,000 jobs in this period of time of less than a decade, and that's just under the total of 289,000 jobs that France managed to create between 2007 and 2015. So again, this is the brightest spot in an otherwise dismal picture of job growth, and particularly new job growth. Now, obviously, these developments have raised important questions about privacy and antitrust and competition that are being debated here in Europe. We were weighing in on these debates, and it was just we're so grateful that Julie Brill and Bruno would be with us today as the two key regulators trying to cut the Gordian knot on safe harbor, which is a huge concern for a lot of companies on both sides, but particularly as we talk to people for small and medium-sized companies. The big actors are going to find a way to deal with whatever you all come up with, but it is the small and medium-sized companies that are really going to be faced with potentially very large transaction and opportunity cost if the regime that emerges is one that is too restrictive. So we hope that that will be kept in mind as you all do your work and as we try to wrap this up. In conclusion, I would just say that this is a pretty important test, again, of our ability as transatlantic partners to solve problems before us. If we are now looming behind this as the TTIP negotiation, where we're talking about regulatory harmonization across the economy-wide, across the board. And if we can't get it right on this critical area of cross-border data flows, that doesn't bode well for our ability to have success as we go into the TTIP negotiations. So for all those reasons, terribly important, and we're just very grateful to Bruno and Julie and to Paul for having created a great opportunity to discuss the specifics, but also to remind folks of the bigger stakes involved.
Thank you, Will. Can I have a round of applause? We're running into a little bit of time trouble, so I just wanted to say I'm going to let the two of you have the floor again in a moment, but first we'll take some questions from the floor. And if I could call on my friend Zoya Shevtalovic first. Zoya, it's nice to see you again. I'm sorry we couldn't have you on the panel this time, but it's good to see you here. I'll call on you next, sir. Thanks.
Thanks, Paul. I do have a couple of questions. Zoya Shevtalovic from Politico. I have a question for you, Julie. So it seemed to me that you were indicating that the FTC was willing to actually give some sort of legislative promise or something of the sort that they would investigate any of the complaints that come from the DPAs in Europe. And that seemed to be something that Bruno was saying was perhaps a big issue, that there was no specific guarantee because the FTC is not an enforcement body, that the FTC would investigate each individual complaint. So I'm wondering whether that's what you were saying, if there's some special, or perhaps you weren't saying that, Bruno, but that was the implication, I suppose. But Julie, so are you saying that you will be investigating, you will be sort of promising to investigate every single complaint that you get from the DPAs in Europe on safe harbor?
I think I need to respond to this. I know you want to get more questions. So there's so many incorrect things in the premise of your question. So let me just be really clear. The FTC is an enforcement agency. We are first and foremost a law enforcement agency. That's what we do, and we do it really well. We have many of the very largest companies under 20-year consent decrees. We have some of them who we've investigated for violating those decrees, and we have obtained millions of dollars in penalties. We have obtained billions of dollars in some of our privacy-related cases in terms of restitution for consumers. So law enforcement is our bread and butter. What you also appear to have not correctly understood, or I failed to communicate it correctly, is we have always committed to taking each DPA complaint that we received as a priority. We've always said that since the very beginning of Safe Harbor. And to date, we have received 4 referrals from DPAs in Europe. Now, that's okay. The DPAs are busy. They've got a lot that they're doing. We've got a lot we're doing. I'm not complaining about that. I'm just saying it's a fact. And but we've always said that we will give a high priority to DPA's referrals because they're our sister agencies. And we are saying that we will be continuing with that commitment. So there's not a change there. I do think, we want to make sure that the DPAs know who to contact, right? That, if they think that they've given us more referrals and we haven't received them, that there's there's someone at the end of the line, they're getting to the right person. Maybe they'll work with the Commerce Department, maybe they'll work with others in the U.S. government to make sure that we know when they have an issue that they think they need help with. We do want them to do screening, that's their job. They need to look at all the complaints. So all of that, we are in discussions with them with the Commission with respect to, but I really don't think that this is anything new, because we have made this commitment from day one that we would give a priority to any referrals we got. And let me just add, because we didn't get referrals, we took it on our own. Anytime we were doing an investigation of a privacy matter or a data security matter, we looked at whether the company had signed up for Safe Harbor. And if they had, we would investigate and add allegations about whether the practices that we were looking at were also a violation of Safe Harbor. And in several cases, we on our own said, okay, this appears to be a Safe Harbor problem. So it's not like we were sitting around waiting for the DPAs. I mean, again, I'm not complaining about the 4 referrals over 15 years. I'm just pointing it out. But I'm saying that that wasn't all that we did, was simply wait. We proactively brought cases on our own, and the total number of cases that we brought was 39, plus a very important case involving one of the companies that provided seals for Safe Harbor members, which is known as Trustee. We were concerned, we alleged, that they weren't doing the type of investigation and a reauthorization of membership into their program that we felt that they should do. So hopefully that straightens out that discussion.
Okay, thank you. The gentleman just there, and if you could identify yourself.
Stephen Gardner from BNA. I'm also a journalist. BNA, it's a media, Bureau of National Affairs in the US. It's a subsidiary of Bloomberg, in fact. So from what I understood, it didn't sound like a deal's going to be done on a Safe Harbor 2 by the end of January. So are you able to provide an estimate of when a deal might be done? And are you concerned that the DPAs are now going to start stepping in and flexing their muscles and stopping transfers? And maybe a question to the Commission, specifically to Bruno. Does the Commission accept that the US protections are essentially equivalent to those that we have in the EU, and therefore the issue is rather proving that rather than getting the US to do anything new?
Paul, did your hand go up? I thought I saw another hand here somewhere. Oh, don't tell me there are no more questions. I can't believe that. We're not going to be able to come back to the audience again. So are there any more questions now? Okay, yeah, Mark Spellman. And can you introduce yourself?
Yeah, Mark Spellman, World Economic Forum. I'm interested in the question about policy innovation, because it seems to me one of the real problems is that we're always playing catch up. So you talked about the annual sort of joint review as one of the innovations going forward. Can you perhaps enlighten us, particularly in the light of the, if you like, the big innovation trends that you see coming? What do you see as the critical innovations in policy making that we're going to need to be able to keep up to date with the pace and scale of technology change?
Okay, thank you. And on that note, I'm going to abuse the microphone and ask the last question myself. And I apologize, I'm a very lazy man. My question is, Julie, is there anything that you would like to ask Bruno? Anything that you heard in his remarks that you think could be clarified or perhaps additional explanation? And Bruno, I'd like to put the same question to you. Is there any question that you would like to put directly for Julie in this unique context that rather than having coffee or sitting down over a negotiating table, we happen to be sitting in front of the whole world? And on that note,
Would you like me to start?
would you like to go first, Julie?
I'm happy to, unless Bruno, would you like to go first?
No, well, I have questions that I will reserve for another
Another setting.
but I have
Sure,
some
of
answers
course.
to provide to some of questions. But go ahead.
Okay. So,
Maybe I will answer to your question by another question. That will
oh,
be,
that's a very good tradition that I abide by all the time, so no problem. Actually, more than a question, I'm very pleased that Bruno noted that not just that when we're looking at the U.S. privacy framework, again, somewhat complicated, but I believe quite robust, we need to look not only at the federal system, that is what is happening and what has been enacted by Congress, but we also need to look at what the states are doing. As some of you may know, but maybe others of you don't, before I became a commissioner of the Federal Trade Commission, I spent 20 years working at the state level as an assistant attorney general. And what I did was I led the state attorneys general privacy working group. So I know this issue very, very well. And I just gave a speech last week about the GDPR, and I noted that it is not a purely European document. What it demonstrates is that there is a robust conversation, I think, between some of the best policy innovations in the United States being adopted and imported into Europe, as well as Europe trying to let everybody know what it thinks is appropriate. So not just data breach notification laws, as you mentioned, but also, frankly, the Children's Online Privacy Protection Act and the notion that verifiable parental consent is needed for children under the age of 13. Maybe some of the member states will go up to 16. That's going to be discussed going forward. De-identification and the elements of what robust de-identification means is something, as best as I saw, that really looked very close. The GDPR clearly looked, or the drafters of the GDPR clearly looked very closely at the FTC's 2012 rethink of our privacy framework in the United States. So there's a really robust conversation going on between Europe and the United States about some of these policy innovations, to go to that last question. And I'm really pleased that Europe is recognizing what Louis Brandeis called the laboratories of democracy that exist in the United States. I mean, California has a student privacy law that the president has called for enacting at the federal level. And why? Because the president looked at what California had done and thought it was really good. California has some other privacy laws, for instance, requiring privacy policies and whatnot. So in order to truly understand this essential equivalence issue, I think we need to look not just at the federal level, but also what's happening at the states. And there's one more thing states do that I think is very important. I don't think it's worth getting into how we handle complaints at the FTC and how we do all of that. That is obviously, as Bruno mentioned, something that's very much under discussion. But the state AGs run mediation programs where they do respond to every complaint that's filed by contacting the company and getting a response. So it's a complicated system, but you need to know it kind of both horizontally as well as vertically. So it was really not so much a question as really almost thank you. It was thank you. But yeah, no, go for it.
I have a question, but first I want to answer some of the questions, and then I have a question for you.
As do I, but why don't you go, and then I'll answer some of the questions too.
First, I've never said that a deal is not feasible for the end of January or beginning of February. I've said the opposite, is that we believe that we have made proposals that are make a deal feasible, and that are, as I say, building very much on elements that already exist, bringing them, of course, developing them and building on them. So, meaning we are negotiating these very days and these very hours, I would say, with that objective in mind. As you said, the Commission, by the way, it's not a big secret. The Commission, in its November communication, indicated that time horizon. Then, of course, as in any negotiation, you don't negotiate with yourself, fortunately or unfortunately. You negotiate with a partner, and the dynamics of the negotiation, the outcome of the negotiation, and the moment in which the negotiation ends depends of that interaction. But we are approaching what we hope is the last mile of this negotiation with, as I said, constructive spirit. The question you asked about essential equivalence, that's exactly what we will have to, the finding we will have to make, and most probably, because most probably a new arrangement will be challenged, and it will most probably cover all aspects of the framework, because the Schrems case, of course, it's a landmark case, but it was a case on specific issues, as many judgments, as all judgments, especially reference for preliminary rulings, a specific set of facts. Probably when the new arrangement will be challenged, it will be on the whole package, if you want. And we will agree to that package, adopt a new adequacy decision when we will be able to say that we fulfill the requirements of the court as regard essential equivalent, and that's why we are negotiating the points I've mentioned, where we are seeking and we are working, and I hope we will obtain rapidly improvements and commitments. And one of the improvements, to come back to one of the questions, one of the improvement we need, or one of the conditions we need to meet, is what indeed the court says in paragraph 81, which means that every complaint has to be properly handled and resolved. And that can be done in different ways, involving institutions and enforcement on both sides of the Atlantic. And that's the model or the mosaic we are trying to establish. But that's certainly an essential part of the, without playing with words, of the essential equivalence test, because we are in a fundamental rights area where individuals benefit for certain protection and need to need to have a system that properly and appropriately and handled and resolve their complaints. Then my question, now I'm coming to my question. Okay. You said that there was, and I agree, there's this dialogue, but I hope it's a mutual dialogue. So clearly we have a draw, and I see, by the way, a representative of the Luxembourgish presidency, even if I don't have I don't have glasses on me, but the chair of the DAPIX, and therefore, and Lord knows how much, all these aspects, knows very much these aspects of the regulation you mentioned, and that indeed on some of these aspects we have drawn inspiration, but I don't think it's a one-way dialogue. I hope it's a two-way dialogue. Are there aspects in the present debate in the United States that are influenced by what we're doing here and what we have done? And
look, there are people who have said, the representative Ishu, who represents Silicon Valley, I was out in Silicon Valley a few weeks after the Schrems decision, and she said it was 7.6 on the Richter scale. 7.6 just happens to be the level at which the 1906 earthquake hit San Francisco. It means it's a big earthquake. It was a big shock. I think that policymakers, the technology community, other stakeholders, other businesses are paying attention. I think that they don't necessarily agree that everything in the GDPR is going to lead to the right balance, going to your wonderful question, which I want to get to, between innovation and protection. I think that some of the GDPR was being negotiated as long ago as 4 years ago, right? Some of the things that are going on with respect to the Internet of Things and big data analytics and potential benefits, which are huge, as well as the potential risks, I don't know if, and I think people are looking at the extent to which the GDPR gets the balance right. And it's something that we're going to need to discuss. So, with respect to this two-way dialogue, which I very much want to promote, I want to point out that, and this also again goes to this last question about how do we ensure that our policy is as innovative as the technology community is, and as business models are, right? It's both technology and business models. How do we ensure that we are up to snuff when we're looking at policy developments? And here's what the FTC does, and once again, I really think we do this really well. We hold workshops on cutting-edge issues, and we bring in stakeholders, frankly, from all over the world to present to us, not just from companies, not just from think tanks, but also from consumer advocacy, from universities and elsewhere, to come in and talk to us about cutting-edge issues. So what are the things that we've been looking at just over the past, say, 6 months, 9 months or so? Cross-device tracking, huge issue. Which means that it's tracking not just with respect to one device as a consumer moves from website to website or service to service, but how companies are now tracking consumers with respect to multiple devices to identify one consumer. And by the way, this is not just happening in the United States. This is absolutely happening worldwide. Ad technology, how are ad networks serving up, monetizing apps, which is, of course, something that's good because these are services consumers want. But how are consumers being given choices about the tracking that's going on, whether it's cookie-based or whether it's some other form of tracking? We just had a presentation this morning at a different conference where I talked about a research that we've done with respect to health apps and user-generated health information, how that's being tracked. Someone from a Norwegian Consumer Council did the same study and showed that with respect to European apps, the same thing is happening. One other conference I want to mention that we just held was called PrivacyCon. So kind of like Comic-Con, but nobody dressed up. Nobody came in outfits or anything like that. But what we did is we brought in cutting-edge researchers from all over the country and all over the world to talk about their latest research on a number of different issues. Usability tools for consumers, de-identification, whether it really works and when it really works. One of the best presentations that I saw was from a gentleman from Columbia University. So we had folks from Stanford, from Berkeley, Columbia. We had some folks from Australia, from England. A guy from Columbia is working on a tool that companies can use to analyze internally, to take a look at their own data and their use of data to determine whether they're having disparate impacts on vulnerable consumers. To me, this is one of the issues of the future that we absolutely need to be thinking about. So we saw a presentation that this can be done. Now it's going to require companies wanting to do it. It's going to be them examining their own data and making a determination as to whether they're treating their customers fairly. To me, this is incredibly important. We want to have workshops with our European DPAs. One of the principles that came out of the last International Conference of Data Protection and Privacy Commissioners in Amsterdam, it was all about bridges, building bridges across the Atlantic. How can we in the United States work more closely with Europeans and vice versa? How can we ensure that it's a two-way street? The very first recommendation was that we hold joint workshops, that we do our workshops, which I think are a wonderful model where we learn so much and it informs our policy making. We do that with the Europeans so that they can get the same input and learning. So that's just part of an answer to a very, very important question.
Thank you. Bruno, I know you have to leave because deals not only have to be sold, they have to be negotiated. Oh, I hope so. Before you leave us, would you like, or do you have any parting words or anything to say?
No. I thought your answer to my question was an interesting one. At least my take from it is that what we do here in the area of privacy matters. And it might be for some controversial. I think it's also a great inspiration also for the United States. And that's, I think, something that I will take back.
You have everyone's attention.
Yes.
Let's put it that way.
Yes,
you
yes,
have
yes.
everyone's attention.
But sometimes it's also positive attention.
Let me just say on behalf of everyone in the room today, I think all of us are relieved by this discussion. There are various rumors that fly around, but seeing you here, seeing you engaging together constructively and positively fills me with hope that not only will we someday have an agreement in these areas that will be to the mutual advantage of both of our societies, but we might even be able to have it in the coming days. And I wish you both enormous success in that. Can we thank our panelists here today? Briefly, the invitations haven't gone out yet, but the Lisbon Council will be back soon with the Innovation Summit on March the 10th. Commissioner Moedas is coming, and he'll be presenting the Commission's study on innovation and competitiveness. And for those of you who've had a day even half as long as mine, we'll be serving drinks outside. I hope you can stay for a while and get to know the other people here even better. Thanks for coming.